Good morning, everyone. My name is Charissa Fajardo, and on behalf of the Canadian Helper Society, I warmly welcome you to today's crucial session on Wills of Powers of Attorney in Ontario. This important educational program is made possible through the generous support of the Government of Canada New Horizons for Seniors program. Planning for the future can feel overwhelming, but understanding for legal rights and options is one of the most caring and responsible steps you can take for yourself and loved ones. The decision will demystify the process of creating a will in Ontario, explore who can make these important documents, and explain the two types of powers of attorney that can protect your interests and wishes. We're honored to have Angie Pham with us today as a social worker and community development worker at Services, currently pursuing her Master of Social Work at Wilfrid Laurier University. Angie brings over 13 years of experience supporting individuals with diverse needs. Her commitment of empowering vulnerable population makes her the ideal guide of this important topic. Yeah,
Guess I'll take over.
you can
Thank
start
you.
now, Miss Angie.
Thanks so much, Teresa. It's nice to meet everyone here. Good morning. My name is Angie. I'm going to do an overview, a brief presentation for you on wills and powers of attorney today. And I just want to note that the rules around wills and powers of attorney is only pertaining to the province of Ontario. The information I present will only be applicable to being in Ontario. If you leave Ontario, the rules might change a little bit. So I just want to make that clear. Um, Welcome. Again, my name is Angie. I'm actually graduated now. Thank you, Teresa. Yes, I've been a social worker for over 15 years in different areas of social work and in the community. And my background is Vietnamese. So my parents came as refugees to Canada. And, I grew up and I've witnessed and I've observed and experienced myself the barriers that our communities face being newcomers to Canada. So I think this work is important. And I think it's really important to share this information as publicly as easily as possible because, for example, in my family and in my community, there's a lot of misinformation that goes out there. Friends tell friends some information that they heard or somebody told them, and it might not be correct. And then we pass on the misinformation and the false information. So I hope I can clarify some legal information today. If you have any questions throughout my presentation, please feel free to unmute or maybe put in the chat. I will do my best to answer. However, I just want to note I'm not a lawyer, though I do, my full-time job is working in a legal clinic. My capacity is a social worker. So if I can't answer your question today, maybe we can connect after and I can find the answers for you. Yeah, so I will continue from there. Just a disclaimer that this information that I share today is only construed as legal information and not legal advice. And the difference is legal information is general, it's broad, it's what's written in the textbooks. However, legal advice is very specific and unique to your case. So, for example, if you say, I have 5 children, can you help me decide on who to leave my belongings to after I die? I probably can't give you that information today, but this is general information. And also to note that the information I present today is applicable as of today, July 12th, and it might change in the future. So if it does, please forgive me. So I'd like to start off my presentation with like engagement and if you don't want to respond to my questions, that's okay. Just for your own thinking or your own reflection, if you can follow along with my little quiz just to check with what knowledge we already have. So we're going to do kind of a true and false question. Please feel free to answer or just think the answer in your mind. That's okay too. Okay, my first question is, a will is only valid if it is prepared by a lawyer. Is this true or false? I'll try to have the chat
False.
open here. I see some thinking
Mm.
minds.
Yeah, it is
So,
clearly false as long as it proves that it is written by by that person. Yeah.
all right. That would be correct. So that would be false, and we'll get into that a little bit later. This quiz is just meant to make you think about what information you already know. And there's no bad answers. Also, I just want to note, if I talk too fast, please feel free to raise your hand and slow me down. Okay, regarding wills, a common law partner does not have the same benefits as a legal spouse. Is this true or false?
Uh, Again, I'm maybe talking too much.
No.
It depends on the country.
Mm,
Because, yeah, in Canada, I believe they have same, uh, they are same, but in somewhere else, like Iran,
mm,
they don't, there is no law partner, doesn't define on the law.
right.
But in Canada, I believe it is same.
Mm. Does anybody else have any thoughts? Thanks, report. Um, Okay, so I just want to remind that my presentation is only pertaining to the law in Ontario. So again, like Shapur mentioned, if we leave Ontario or leave Canada, the rules might change. However, in Ontario, the answer is true that a common law partner does not have the same benefits as a legal spouse. So even in Ontario, a legal spouse, like a married partner, and common law partner are not equal in the eyes of law. A will can be handwritten. Is this true or false?
Everybody says true, but I don't know why they are not turning, they are muted. They don't, we can't hear.
That's okay. We're all shy. I get it. Sure. That is a good answer. That is right. A will does not have to be typed. It doesn't have to be done up by a lawyer. It can be handwritten, and we'll go into that a little bit more later. Okay, this one, a will can take effect before I die. True or false?
True.
I think someone said true. Okay. Anybody else? Okay.
True.
Okay. Thank you. So the answer might surprise you a little bit. A will can take effect, can't take effect before you die. That would be the second part of my presentation will be on a document called powers of attorney. And those are the documents that take place, can come into power before you die. A will can only take effect after you die. But thank you for your answers. And this is why we fact checked with ourselves and for this presentation. Okay, and oops, I spoiled the answer for this one. So there is only one kind of power of attorney document. Is this true or false?
False.
Anyone else? All right. That is right. Ferde,
Yeah,
thank you.
actually, what does it mean, power of attorney? I have power of attorney document. I have no clue on it. What does it mean?
That's perfect because that's what this presentation's about. So I will hope to provide a little information about what that is. A lot of
Sure.
people think that there's only one document called the will, and the will takes care of everything for you after you die and what your belongings are. But there's actually another really important, two important documents called powers of attorney. And we'll talk about that. They're actually, I would say, as important as wills. So again, today my presentation will provide, oh, sorry, thank you for doing this quiz with me. So today's presentation will provide an overview of wills and then the two types of powers of attorney documents that are out there. So one is called the powers power of attorney for personal care, and the second is called continuing power of attorney for property. And I'll provide more detail, but to give you a little bit of a distinction, wills again take effect only after you die. So they're going to be a set of instructions you leave for what happens to your belongings, your home, your car, like your decisions after you die. Before you die, you can create these two documents called power of attorney for personal care and power of attorney for property. And those set out instructions for what happens if you cannot make decisions on your own, but you haven't passed away, you haven't died. So for example, someone who becomes comatose, they get into a car accident and become unable to make decisions for themselves, the power of attorney document would be the one used to make decisions about what to do. Like if you set out instructions for, if I'm in an accident and I will never wake up, but I'm still alive, my decision is for my family, my surviving family, to pull the plug and let me go peacefully. So those are the documents that set out your instructions and decisions for before you die. And I'll get into that a little more later on. So the first section I want to talk about is wills, because this is an area that a lot of people are they question but have misinformation about. So what is a will? A will is a written document that sets out your instructions for what should happen to your estate, which means your property, after death. It also names a person. This used to be called an estate trustee, but is now called an executor. So it names a person called an executor who will carry out the terms of your will. So, for example, if I have a will that says, after I die, I want my puppy to go to my cousin, then I assign my best friend, Kim. Kim is the one who will take my will and say, okay, I have to find this cousin. I'm going to give the puppy to the cousin. So that is the executor. They carry out the instructions in my will for me. So the executor, it used to be called an executor. The law recently changed where it is now called an estate trustee. I don't know why they changed that name, but for all intents and purposes, it's called estate trustee. So the estate trustee is responsible for paying all of your debts and ensuring that your property goes where your will says it should go. A will takes effect after your death. So again, my estate trustee, Kim, would be the one who looks at my bank account, what money I have left, what assets I have left, ensures that if I have any debt, that gets paid, and then they follow the instructions in my will and carry out those instructions. Whether that's, this diamond ring my grandma gave me will go to cousin A or something like that, then estate trustee would be the one to look after that for me after my death. Who can make a will? Anyone over the age of 18 can make a will. When you make a will, the law says that you have to be of sound mind. Sound mind means that you do not have a mental impairment that stops you from knowing what you're doing. So what it means is you're fully alert, you know what you're doing and saying, you don't have anything that's stopping you from understanding what you're doing and saying, nothing to impair your decision. That means you're of sound mind. But for example, if someone is, very injured and they're delirious, they don't know what they're saying or doing, and then they say, I want to change my will, then that wouldn't be applicable. So just to show you the example. So what would happen if you die without a will? So a lot of people don't know if they should make a will. They don't know when to make a will. A lot of people are scared about the idea of making a will. Accidents happen, life happens, and a lot of people will die without a will. And it can get very complicated for their surviving friends and family. So if you die without a will, it's called dying intestate. That's the word the law uses. Your property will be divided according to the Succession Law Reform Act, which is just another fancy name for the law, which might be different from how you would have divided up your property. and I'll explain that. So for example, if you have a will, you can be very specific about who gets what happens to all of your belongings, your pets, your children, stuff like that. But if you don't have a will, then there's a law that will decide for you. And it's not always what you wanted. So also because there's no estate trustee to administer the estate, which means to make those execute those decisions for you, an application may have to be made to the court to appoint someone to act as your estate trustee. And this may take extra time and money. So what that means is, for example, I want my son to be my estate trustee. I want after I die, he decides on what, or like he figures out what happens to all my assets, all my bank accounts, but I didn't have a will. So he isn't my estate trustee yet. In the eyes of law, he's not officially my estate trustee. So if he wants to be my estate trustee, he has to make an application to the court because there's no will, there's no formal document saying I want him to carry out my wishes. Does that make sense?
Yes.
Thank you. So again, what happens to my estate if I die without a will? And the word estate means property and assets. So that's like everything. Everything you own is called estate. Everything you own and like belongs to you is your estate. So according to the Succession Law Reform Act, so the law, unless you have someone who is financially dependent on you when you die, and that person makes a claim, your spouse is entitled to up to the first $350,000 of your estate. So that's just up to. And your spouse also has the option to claim half of the net family property. So again, this is only applicable if you're married. If you're not married, forget this. Anything over $350,000 is shared between your spouse and your descendants, so your children and your grandchildren, according to specific rules. So if there's no spouse, your children will inherit the estate. If any of them have died, that child's descendants, so your grandchildren, will inherit their share. If there's no spouse, if you're not married, you don't have children or grandchildren, your parents will inherit your estate equally. Now, in the case that you don't have any spouse, no children, no parents left, no surviving close family, if you have brothers and sisters, they'll inherit your estate next. And then if any of your brothers and sisters have died, their children, so your nieces and nephews, will inherit their share. So you can see how if you don't have a will, this can get a little messy. If you have a will, you can be very specific. I want my child, Bill, to have $3,000. I want my daughter, Kim, to have $8,000. However, if you die without a will, this is how the law will decide for you. So it goes spouse, your children, your grandchildren, then your brothers, your parents, then your brothers and sisters. And sometimes you don't want to give money to your sister or your brother or a niece that you know is very irresponsible. So that is why it's so important to make a will. But again, I'm just outlining what happens if you die without a will. If you don't have any surviving brothers and sisters, your nieces and nephews inherit the estate equally. However, if your niece or nephew has died, their share does not pass to their children. So it doesn't just keep going down the line. It stops with, nieces and nephews. And then when only more distant relatives survive, so for example, your cousins, great nieces, nephews, great aunts and great uncles, the rules become really complex, and that's when you should seek a lawyer. Or sorry, whoever's surviving should seek a lawyer. This is only for after you die, so you can't do anything at this point, sorry. Essential components in a will. So what goes into the will? The will has to include these 4 things. And if it doesn't include these 4 things, it's not a valid will. So there's a clause to name a estate trustee. So you have to decide who will be your estate trustee. I trust my will and the decisions in my will to blah, blah person, my sister, Anne. Who your beneficiary or beneficiaries are. So who inherits your belongings, your assets. When they say beneficiary, it's who gets all your stuff, who inherits. next, you would name your guardians for children under 18 years of age. So if you have children under 18 years of age, you would designate someone to be their guardian. So that would be, my child is only 5. If I die, my brother will take care of my child for me. And then lastly, your will has to say what your wishes are for any specific gifts and the residue. So that would mean, like I made an example before. I have a diamond ring from grandma that she gave me, and I want that to go to my daughter when I die. Residue is like all the other little things if you want to note them. So I've seen people who are very picky about who will get what. So it's like my car will go to my son, and my ring will go to my daughter, my bracelet will go to my next daughter, and it gets, that's the residue. That's the specific gifts that you want to leave behind. And you can be very specific in your will if you want to, and outline who gets what. Just want to do a check. Everything's okay. Going along okay.
Yes, everybody okay.
Okay, thanks. It's because I can't see the chat before, so please feel free to interrupt me.
Sure.
I'm going to talk about a few ways to make a will. Again, I know that the process and even the thought of making a will can be really scary to people. The idea of death is often very scary. People don't want to think about like what happens after I die, but not to be too dark, we all will die at some point. So it is really good and really important that we prepare ourselves and we think about what decisions to make when we still have the power to do it. These are, it's our life and our belongings and our family that we have to think about, in preparation. So I'm going to go over a few ways to make a will. I think a lot of people think, oh gosh, making a will is really expensive. It doesn't have to be. There are a few options that are much cheaper than you think. Some that are free, which I will provide in my presentation. So number one is there is a website that is run by our Ontario Community Legal System, and it's called CLEO. It stands for Community Legal Education of Ontario. There's a webpage that is a guided pathway to making a will. So it provides an interactive interview that can help you prepare a free basic will. So what it means is it's not a person, it's a machine, but it says like, who do you want to leave your assets to? How much do you want to leave them to? Any notes, that kind of thing. So you just kind of fill it out. It's quite easy to use, but you fill it out and then it'll create a will for you because it's run by, it was created by lawyers. You can appoint an estate trustee to pay your final bills, do your final tax return, and distribute the property in your estate. So here I have the webpage or the website, and I'm happy to share this afterwards as well. But it's stepstojustice.ca/guided-pathways. A really great resource altogether. Clio and Steps to Justice are really great legal resources that are free and very easy to understand. And then we talked about this briefly during our true and false quiz at the beginning, but a will can be handwritten. However, there's very specific rules that have to be followed for it to be legal. So you can write what's called a holograph will, which is a handwritten will. However, a holograph will can only be handwritten and created and signed by you. The word in the eyes of law is a testator. You as the person deciding on your will is a testator, without the help of any mechanical processes. So what it means is a holograph will is completely 100% handwritten by you. You must clearly state your name. You have to write, "This is my last will and testament." You have to name who your estate trustee is. It can be one or more than one person, and what your wishes are. So what that means is I could handwrite right now if I didn't have a will and I'm really scared that, something might happen to me. I could handwrite a will and it can say, "Hi, not hi, sorry. My name is Angie Pham, and this is my last will and testament. My estate trustee is my sister Kim and my brother Bob," for example. And then I would like them to just pay off my debts when I pass away using whatever's in my bank account. I want my car to go to my daughter, and my I don't know, my computer to go to my son. So you can be a little bit more specific, but it's a very basic, cheap way to create a will that is legal, as long as these 4 criteria are met. Any questions before I continue? Okay. And please feel free to interrupt me, even if, I keep going. The next option is to buy a will kit. So a few things to remember if you buy a will kit. You can easily do a Google search and find a valid will kit in Ontario. That's not a problem. But a few things to remember is it must be for an Ontario will. And that's very important because I think there's a website called like canadawills.com or something, but just you have to be very sure that that's applicable to Ontario, because like I said, if you leave Ontario, the rules might change a little bit. It must be dated. So whenever you do this will, be sure that it is dated appropriately. And it must be signed in front of 2 witnesses who must also sign in your presence and in each other's presence. So that means I buy this will kit, I print it off. I have to find 2 witnesses who are unrelated to me. So that means it can't be a family member, it can't be a beneficiary. So, and then they have to be there when I sign the document, and they have to be there to sign at the same time. And then a few rules around that is like it can't be family, so that's a conflict of interest, because say I left my diamond ring to my daughter Kim, and Kim signs as my witness. That wouldn't make sense because she's the one receiving the assets that I'm leaving for her. So that would be a conflict. So it should be 2 unrelated people. It should be like 2 friends or 2 acquaintances, like my neighbors, 2 neighbors, 2 people I work with, for example. So they shouldn't be related to you. They shouldn't be any benefit. They shouldn't get any benefit from your will, and that would be legal. And then lastly, it would also require an affidavit of execution by one of the witnesses. And what that means is one of those 2 witnesses that you choose, if you use a will kit, they have to provide a short document that says, I was present for this signing of a will. I know that this person, my friend, is sound of mind, and I was a witness to them signing their will. So a will kit is an option, but not my favorite option by far.
Excuse me. Witness is a suggestion or is a must?
2 witnesses is a must.
No witness, so it is not legal.
Right.
Okay.
If there's no witnesses, your typed up will, like the will kit, is not legal. Because in the eyes of law, there's nothing to prove that this was done with your permission by you. So, for example, if say my mom, I could type up a will for my mom and say that was for me. That my mom made that for me. So it has to have witnesses to prove that it was done correctly, of sound mind, and with no coercion.
And I believe you said that the witness cannot be the close relative.
That's right. Yeah. So, for example, let's say my sister. So, I can't ask my sister to sign my will because she might inherit some of the stuff, or she's too closely related to my daughter. Maybe she really likes my daughter, but dislikes my son. So, it could come into issues of being like, she's in favor of one child over another. It just gets too messy. So it can't be a family member. It can't be someone who, is a beneficiary either, because, it can be a little fishy.
Thank you.
Thank you. Are there any other questions before I continue? Okay.
There's a question, Miss
Yes.
Angie,
Yes.
one of our participants. What are the first steps we should take if we want to create a simple and legal will for our loved ones?
That's a difficult question for me to answer just because it's all about free will. So, whichever method you choose is completely up to you. I'm only able to provide the options of creating a will. That being said, after you hear all the options that I'm going to present on creating a will, you can kind of decide what would work best. I mean, give you an example. My mom is someone who really worries all the time. She's worried, if I do this incorrectly, it's not going to be illegal. And if I die, Angie won't get my belongings. So she will pay money to go to a lawyer and get her will done just because she's so paranoid and so worried that this will go wrong. But someone who understands, it's not as scary as it might be, might just do a holograph will. They don't have a lot to note anyway. So, for example, like someone who is single, doesn't have a car, doesn't own their home, um, just wants to leave like simple instructions for their child. Like, I don't really have any assets, but like I want my daughter Kim to pay off my debt after I die, and cremate me instead of bury me. Something very simple like that. You can make a holograph will. That is an easy, free, simple option. But again, the decision on which method to use to make the will is up to the person and what means they can afford. Because a will is not too expensive, but it is expensive for some. So I want to say like 7 years ago, maybe I made my will, and my lawyer charged me, I think it was $300. Now you could be looking at seven, maybe $800, and it also depends on how complex your will is. So me being a single woman, no children, my will was very simple. If I die, my parents will inherit my assets, and if they die, then my money will go to charity, for example. So my will was very simple. It was like 5 pages. The lawyers only charged me $300. But say I have a family of 18 people and I want, child A to get this, child B to get this, child C to get this. It becomes a really long and complex document. So the lawyers might charge a little bit more. So again, that's something that if you're creating a will, you have to consider costs, what makes sense, what you have, what you want to include in your will to make a decision. I hope that makes sense.
Miss Angie, is it can be handwritten with holographic will be valid without witnesses?
That's right. Yes, because it's in your handwriting. So if it was ever questioned, I mean, I'm sure they'd have like forensics, like compare your handwriting from somewhere, like another document somewhere with your handwriting in your will, and that's seen as valid. But again, it's a very simple will that you leave if you write a holograph will. Because personally, I wouldn't want to write like 8 pages of like handwritten notes on what happens after I die. So usually, when I see a holograph will, it would be very simple. It'd be, I'm a single person. All I have is my dog, and whatever is in my bank account. So if I die, my best friend will take care of my dog. That kind of thing.
One more question.
Yeah, please.
In any case, is it possible someone do legal action against a will that this is not fair or this is something, or is it possible?
Yes, that does happen quite often. You will see, like in movies, for example, like legal battles between family members over like, the will says that mom didn't leave me this, but she told me that she was leaving me this. Yeah, that becomes a really complex procedure, and it's a whole court battle, in which like lawyers would be involved. So yeah, it does happen. It can happen where a will is contested and taken to court. Um, but today my presentation like won't go into that because it's a very complex situation down the road.
Thank you.
Okay, and then the last option, as we mentioned, is to hire a lawyer to draft your will. So the cost, this costs more than the other options that I presented. So the holograph will, the will kit, and then Clio, which is free. It does cost more, but the lawyer who you hire will ensure that your will follows all the rules required by law for a valid will. And as I mentioned, like they'll give you advice, which is very unique to your matter, on what you should do. So if you're not sure, your lawyer is there. You're actually paying them to give you advice, to give you their opinion, and like how to proceed with all of your instructions, especially if it's very complicated, or say you have a lot of things that you specifically want to give to specific people. And in Waterloo region, there's a website called waterloolaw.org where you can look up local lawyers for making a will, or any area of law, but especially for making a will, because each lawyer practices in one area of law. Not every lawyer will provide services in creating a will. So you can use the site waterloolaw.org to find a particular lawyer for your needs. Also, you can look them up by name, by gender. Sometimes a woman or man might decide that they want a specific, like a woman lawyer, because it's easier to talk about their personal needs with a fellow woman. So that website's very helpful for that. So this is a question I get, especially amongst newcomer communities. What if I own property outside of Ontario? So again, the will created in Ontario only deals with assets located in Ontario. If you leave Ontario, the rules might change, and that's when you would have to seek information wherever you go. The validity of the will depends on whether it's compliant with the laws where you are, in which the foreign asset is located. So that means, for example, I own property back in Vietnam. My will in Ontario won't cover the belongings that I have back in Vietnam. We'll get into that in a little bit, but just so it's clear that it's only pertaining to your property, like a will created in Ontario is only pertaining to property in Ontario. So in the case that I have property at home in Vietnam, one way to deal with this issue is to have something called an international will. The province of Ontario is part of this agreement. I won't even name it. It's a, convention providing a uniform law, which covers this area of law. However, under the Ontario Succession Law Reform Act, if a will is made in accordance with the rules, okay, this is a lot of jargon. Sorry, it basically means when you seek a lawyer to make a will because your property is back home or not in Ontario, you can ask them for an international will, and that's when they can give you advice on how to make a will that includes property outside of Ontario. Give you an example. I own a car back home in Vietnam. The international will can cover what will happen to that car if I die. If I don't have an international will, the car in Vietnam, like there's no power to control what happens to that car in Vietnam, if that makes sense. Just want to do another little quick check before I move on. Okay, so I'm going to move on to the powers of attorney because this is an area that people are less aware about. People hear wills a lot, but they don't hear powers of attorney. So what are power of attorney documents? A power of attorney is a legal document that gives someone else the power to act on your behalf while you're living. Will is for after you die. Power of attorney is for before you die. And there are two types in Ontario. So there's something called a continuing power of attorney for property and a power of attorney for personal care. They're two different documents and they do two very different things. So the first one is a power of attorney for personal care. When I worked at the hospital, this was something that I encountered every day, and you'd be surprised how many people don't know about this document or don't have one. So a power of attorney for personal care is a document where you name someone to become your attorney basically your decision maker, to make personal care decisions on your behalf if you become mentally incapable of making those decisions for yourself. An attorney is not a lawyer, which is very confusing language. You hear attorney, you think lawyer, but it's not. Power of attorney is just basically designating someone to make those decisions for you. So again, an attorney is not a lawyer, but a person that you trust to make decisions for you when you're not able to do so for yourself. Personal care decisions refer to decisions about your health care, medical treatment, diet, housing, clothing, hygiene, and safety. So, for example, I might encounter a senior who has designated their daughter as their personal care for, their power of attorney for personal care. And that means, my client is senior. She doesn't, know how to organize these things for herself. She's assigned her daughter to be her power of attorney, and her daughter makes her decisions for like what happens for healthcare. So, what kinds of food she eats, safety precautions. For example, decisions like if she goes to the hospital and something happens, how do we proceed? Like, I'll give you another example is someone who's religious. So, because of their religion, they might say like, you know, I don't want to do surgery. If there's an emergency, I don't want to do surgery. I would prefer to just die. Their daughter is the one who, as their power of attorney, makes that decision and tells the hospital that my mom's wishes are that if, it's surgery or death, she doesn't want surgery. So they also make decisions about your housing and your medical treatment. So, for example, if a senior living alone might have personal care support workers who come into the home, their personal, like your power of attorney for personal care, kind of can coordinate that and make decisions on your behalf. And then the second document is a continuing power of attorney for property. So a continuing power of attorney for property is a legal document that lets you appoint an attorney to make financial and other property decisions for you. And again, an attorney is not a lawyer, but a person that you trust to make decisions and manage your property on your behalf. So again, personal care attorney is like just for your health, your diet, your, day-to-day needs. And then your power of attorney for property is the one who takes care of your financial stuff. So like your bank account, your finances, and then like your home, if you own home, a car, if you own a car. And they, can make decisions on your behalf if you appoint them. Depending on how the power of attorney is written, your attorney may have the authority to, one, act for you both when you're capable and when you're mentally incapable, or two, act only when you have been found mentally incapable of managing your property and finances in accordance with the law. So what that means is when you create this power of attorney for property, for example, if I travel often outside of Canada and I say, Mom, I have so many bank accounts that if I leave Canada, I can't make decisions on my investments. So whenever I'm giving you this power as power of attorney for property, to make those decisions on my behalf when I'm not present. Like you basically have the same powers that I do. I've made it this document to make sure that you have the same powers that I do regarding my finances. And then you can make a power of attorney that says this will only come into effect when I'm mentally incapable. So that would be a power of attorney document where you draft and it says, if I become comatose, then my daughter can make decisions on my behalf. But if I'm still fully awake, she cannot. I hope that's clear. Just doing a check that was clear. If it wasn't, I will explain again. Sorry, Shapur, I'm just going to call on you to make sure that was clear and whether I should re-explain that.
It is clear, yes.
Okay, thank you. Okay, so the next question that I always get, do I need a lawyer to prepare a will or power of attorney? real answer is no. You don't have to have a lawyer to prepare these things. Again, you can use that guided pathway on stepstojustice.ca to create it for you. However, a lawyer can guide you through the process and ensure that your will does what you want it to do and that your power of attorney documents are valid and effective. So again, not that I'm pushing for you to hire a lawyer, but it is a very safe, it's a much safer, clearer method to creating these documents rather than trying to navigate them on your own. Okay. So again, what happens if you don't have a power of attorney for health? So I saw this often at the hospital, and I worked at the oh my gosh, the can't think of it right now, but the kidney unit where people go for dialysis. Thank you, dialysis unit, and medical emergencies could happen. So sometimes we would have to make a very quick decision on how to proceed with someone who had a medical emergency. For example, I hope I'm not scaring anyone, but we would get emergency calls for a patient who was in a bed and they're doing a 2-hour dialysis and all of a sudden they went into a seizure and they needed CPR and surgery like urgently. And we have to quickly look for if they have a power of attorney because we can't ask them, hey, what do you want us to do? I know that you're religious and I don't know how you want us to proceed. A power of attorney document is something that's important because it gives me the power to call their daughter and be like, hey, daughter, please make a decision very quickly how we should proceed for your mother who's in need of emergency care. So if they don't have this power of attorney document, there's also something called the substitute decision maker, which makes decisions for you. So the substitute decision maker would be the person highest on the hierarchy of the Healthcare Consent Act. So I'll go over that. If you have a power of attorney for health or personal care, as we said earlier, you could say, my daughter is the first person I want you to call if I have a medical emergency, and she'll guide you on what to do. Like, should I go into surgery? Should you do CPR? Do I want surgery? That kind of thing. But if you don't have that, then the law sets out kind of a ladder of who gets to make those decisions on your behalf as your substitute decision maker. So the hierarchy provided by the government is if you have like court appointed decision makers, so it would start with the court appointed guardian. Then it would fall to an attorney for personal care. So that's why this document is so important. If you don't have a court appointed guardian, then attorney for personal care is someone you've made the decision to give them the power to make decisions for you. Next, it would go to a representative appointed by the Consent and Capacity Board. After that, the decision would fall to your spouse or partner. If those people aren't present, it would fall to your parents or your children. If those people aren't present, then it would fall to a parent with the right of access only. What that means is, say you have no contact with your father, you only have contact with your mother, so that would fall to your mother only, and not your father. They wouldn't call your father. Next, it would fall to your siblings, if you have siblings, and then it might fall to any other close relatives. If none of those people are present in your life, so say you're single, no close family members, then it would fall to a government appointed person called a public guardian and trustee. Sorry, it's more of an organization, but someone there, a representative from the public guardian and trustee, would make those decisions on your behalf. So again, it's important to have a power of attorney document because I personally wouldn't want a stranger making decisions for me. I want someone close to me to make those decisions, who knows my wishes, who knows me, to make those decisions for me. If you're found incapable of managing your property and do not have a power of attorney for property, the Office of Public Guardian and Trustee becomes your guardian of property. So as I mentioned, it's someone that the government appoints to make decisions on your behalf. Family members can apply to the public guardian and trustee to become the guardian of property or apply to court to be appointed guardian. So what that means is if I don't have this power of attorney document already, the Office of Public Guardian and Trustee makes those decisions on my behalf. But my daughter says, no, actually, I know my mom wanted different wishes. And that's when they have to apply to court to be appointed the guardian. It gets really messy. So that's why it's really important to prepare these documents in preparation. Okay, before I move on, I just want to do a time and check just to make sure we're still going okay.
Time maybe 10 minutes left, but
Okay.
a lot of questions on the chat. I don't know.
Okay.
I'm not sure if you have time to answer these questions.
Yeah. Let me very briefly go through this, the last few slides that I have. It might answer your questions. If not, I will do my best to answer them quickly. Okay. So one question is, can I revoke my power of attorney document or my will? So say today, I want this, but tomorrow I want something different. Yes, you can change your decisions. You just have to draft up a whole new will or a whole new power of attorney document. So think carefully before you create these documents. It can be very costly and very, very burden, like it's a big burden to keep changing these documents. Okay, can my handwritten will be legal in Ontario? We talked about this briefly. Yes, that would be a holograph will, but it has to completely be in your own words and in your own handwriting. If it's a pre-printed form that you find online, that's not a holograph will. If it's a holograph will, it has to be completely 100% written in your own handwriting. Who should I make power of attorney for either personal care of, power of attorney for personal care or for power of attorney for property? So name someone that you trust who will carry out your instructions faithfully and fairly. So don't just pick some random person in your family who you think isn't responsible. Pick someone who you know is responsible, who will understand your wishes, someone you trust for sure. Oh, and sorry, it's very important to know that you cannot name someone as your attorney for personal care if they're paid to give you services. So that means, say I'm single, I don't have any close family members to be my power of attorney. I can't ask my doctor or my nurse or my personal care support worker to be my power of attorney because I technically pay them for their services. They're working for me in a way. So I can't make them my decision maker. When does a power of attorney for personal care take effect? So a power of attorney for personal care only takes effect if you become mentally incapable of making your own personal care decisions. In other words, the attorney cannot make personal care decisions for you until you have been found to be mentally incapable. Unless you say otherwise. And that's why it's important to get a lawyer to do these documents for you. Does divorce revoke my will? No, it does not revoke your will. It doesn't make your will invalid. But if you left a gift to your former spouse, the gift is void. So, for example, I made my will when I was still married, and I said my car will go to my husband. If I get a divorce, husband won't get the car anymore. So, if you appoint your former spouse as an estate trustee, that would also be void. So, if I say like my husband was supposed to be my estate trustee, and then I get a divorce, they're no longer my estate trustee. I'd have to decide on somebody else. Same thing about marriage. So in the past, the law stated that if you get married, your will would become invalid unless you state that it was made knowing you were getting married. However, after January 1st, 2022, a law was introduced to change that even after that a will made after this date would not be revoked by marriage. So that doesn't mean it means that your will doesn't become invalid just because you got married. And then quickly in our quiz, we mentioned about common law spouse. So the law that deals with the distribution of estate of a person who dies without a will speaks only of a legal spouse. There's no provision made for a common law spouse. If you're living common law, you have to specifically provide for that person. If you're living common law and die without a will, the property may not pass to the common law spouse unless they make an application for something called a dependence relief. So you can't just say, yeah, we weren't married, but we lived 30 years together. Their belongings should go to me. That's not enough to be legal. They would have to apply for this thing called a dependence relief, prove your relationship, explain the relationship, and then hopefully get part of your inheritance, I guess. Okay. So very quickly, we're gonna review our true and false. So a will is only valid if it's prepared by a lawyer. True or false? You can just think these answers. You don't have to shout them out.
False.
Yeah. Regarding wills, a common law partner does not have the same benefits as a legal spouse.
True.
A will can be handwritten.
True.
A will can take effect before I die. One would be false. And lastly, there is only one kind of power of attorney document, which would be false. So
False.
the answers. Thank you, everyone. And then I will provide these resources, but these are some local, appropriate, easy to understand legal resources in our community. Might give you a little bit more clarification since, my presentation today was a very, very, very brief overview, and you might be looking for a little more info. So I want to thank you for your time and your participation. And then I guess I'll move on to our Q&A. Shapur, I'll pass it to you. Are the questions in the chat? Oh, okay, sorry. I'm just opening them now. What is the purpose of a will and power of attorney in Ontario? How do they differ? I think we've answered that. Oh, yeah. Can a will be changed or updated after it's been signed? So it wouldn't be updated. It would be like you would create a new will with whatever updated information you'd like. The question is, if the will lacks the testator's signature, it is generally considered invalid and ineffective. Yeah, so the testator is yourself. So if you don't sign your will, then there's no proof to say that it's verified by you. There's no proof to say that it was done by you with your instructions and with your directions. So yes, a testator yourself would have to sign the document. Another question, how about a donation? Can someone claim the will of donation even if the heir did not approve? Yes, so I'm not 100% sure on this question, but do you mean I'm sorry, it was Gilda who asked the question. Do you mean like a charitable donation?
A gift donation, like a land.
Oh, okay. So it wouldn't be considered a donation. That would be your assets that you say. So it can be like, I leave my house or my land to a certain person, and you can outline that in your will. So say I bought a plot of land in Kitchener and I hadn't built a house on it yet, but I say like, okay, if I die, this plot of land, even though there's nothing there, can go to my son. I hope that makes sense. What happens in Ontario if someone dies without a will or becomes incapable without a power of attorney in place? I think we talked about that already. What if my executor dies before me or refuses to act? Who takes over? So again, I hope that question was answered already, but yeah, if your executor dies or your estate trustee dies before you, it would follow that that ladder that we talked about, and a new person would be appointed. Or at that point, you might say, it's time to do up a new will and decide on somebody else to be my estate trustee. Okay. And where can you find reliable legal information or assistance? So some of those resources I provided at the end will hopefully give you additional resources and give you a little bit more extra information. I hope that answers the question. And I'm sorry, Shapori, if we're out of time, I will stop there.
That's okay. 1 minute. It's not big deal.
Okay. Can a handwritten will be valid without witnesses? Yes, that is okay, as long as it's 100% in your handwriting and signed by you at the end. Sorry, there's many questions. Thank you for all the questions, and I'm so sorry if I don't get to yours. How can making a will help protect the dreams and future of my children when I'm no longer around? That's a really good question. So it's really important to have discussions with your family. And I don't think families do that enough because the concept of death is so scary. Like, I don't want to talk about my death, but it's really important to have, like, say, have your family over for dinner and say, today we're going to have a really heavy conversation, but it's really important. If I die, this is what I'm leaving behind, and this is who I want to get what. So say I have a son who is really hoping to become a doctor. And that's why I'm going to tell my family I'm leaving him a large amount of money because I want him to be able to take that money and go to school with it so that your family understands your decisions as well. That might not work for you, but that is an important conversation to be had. Like my family, we will awkwardly say, like, okay, I have something really serious to talk about. Let's have a family meeting today. And I will talk about like some big decision about my will. And I want to share it with my family before, I'm not around to. So, talk to your family, see what they need, see what you want to give, what you want to leave behind. And I guess you're the only one who can decide what's the most important to you. So I'll stop there, Shapora, because I know we're out of time, but thank you so much.
Thank you very much.
Yes, thank you very much, Miss Angie. Thank you all for investing your time in understanding these vital legal tools. We hope today's session has clarified the importance of wills and power of attorney, and that feel empowered to take the next step in securing your future and protecting your wishes. These documents are more than legal requirements. They're expressions of care for those who love and instruments of personal autonomy. We extend our heartfelt thanks to Ms. Angie Pham to her clear, compassionate guidance through these complex legal matters. Her expertise and dedication to supporting our community have made this concept accessible and actionable for everyone. The Canadian Helper Society is proud to provide these essential educational opportunities, and we deeply appreciate the Government of Canada New Horizons for senior programs for making this possible. We encourage you to take action on what you've learned today and reach out for